Hi, we talked in the last lesson about answering the complaint. And before we go deeper into that, I thought it would be a good idea to talk about what the moment is, what the moment presents in the litigation life cycle before a complaint is answered. There are a lot of things that it can mean to be served with a lawsuit. One of those things is something that you thought you got away with, you didn't get away with. Another thing could be that something you had no idea you had done, someone is claiming that you did. Those claims might be true, and you might realize that they are the basis for a legitimate legal claim, or they might not be. They might also be a moment, or it might also be a moment where you realize that somebody who had been threatening to sue you wasn't, bluffing. And now you have to take seriously a demand that they had made involving a dispute that you were already aware of. How you proceed at this juncture depends on a lot of things. Depends on, first of all, which of those categories getting sued falls into. And it depends on your circumstances. Can you afford to defend the lawsuit? Can you afford not to defend the lawsuit? What does that mean? Well, on the one hand, someone might be suing you for trademark infringement, and they're claiming millions of dollars in damages. You don't have hundreds of thousands of dollars to litigate the case, but you also can't afford to enter into a settlement where you pay millions of dollars. What this moment represents is the opportunity for your lawyer to evaluate the claims and help you ascertain whether or not you should be settling to a judgment, what your risk reward calculus is. Now, I mentioned just now the term exposure to a judgment. One thing that is very important to understand is that if someone sues you and you have money in the bank, when I say you, again, it could be you, it could be your business, whoever the defendant is, now is not the time to move that money. If you end up having to pay a judgment, your moving of that money will be deemed a fraudulent conveyance, even before you are judged as owing it. Once you become aware of a claim against your assets, moving them around isn't going to help you. I suppose it could help you if you move them in an illegal manner. That is a kind of helping you, right? But it's not a good idea to do things that are against the law for a lot of reasons. One of them is you can get yourself into worse trouble, maybe even criminal trouble. So you have to look at your exposure. You have to look at your risk reward ratio. What are you being asked to give up? Very frequently, lawsuits for trademark infringement, which is the example that came to mind because a lot of my work, really involves you're just ceasing the use of the trademark that the plaintiff claims you are infringing. Maybe there'll be a requirement for a payment of money, or maybe there won't be. However, if the plaintiff hasn't sued you until you started using its trademark for many years, and you built a business, a brand around that trademark, rebuilding your business under a new mark may not be cost effective. Again, depending on the risks of the litigation, the strength of the claim, what you can deduce about the resources of the plaintiff, and the cost of legal representation. One thing you haven't heard me mention is whether or not the claim is a good one. Well, you've heard me mention it, but strength of the claim, right? What if you just know that even though your lawyer says that actually it's a very strong claim, but you just know, you know the truth. You know that you didn't do anything wrong. You know that you're really entitled to use the trademark. That even though the other guy claims first use of the trademark in 2015. You've really been using it since 2012, and you never made a good record of it. But you know you're right, and you'll be damned if you will give in. So this is the juncture where frequently clients say to lawyers, Ron, they frequently say that, of course, only if their lawyer's name is Ron. I'd rather give you the money than give it to those guys to settle this case. And, you know, in a certain respect, I would rather that you'd give me the money also. But in a much more important respect, I wouldn't, because you might end up giving it to me and giving it to the plaintiff. No matter how good of a job I do, I may not be able to get you out of this. Then you will not only have given me money, you will be sore at me. No matter what you tell me now, you will blame me if you lose. Oh, you will. It's just human nature. There have been exceptions. I've had great clients who have understood that we did our job, but the other side had better resources, or that the judge made some huge mistakes, whatever the case may be, or that there was just a jury involved. Once there's a jury involved, really everything is up for grabs. Filing the answer versus filing a motion to dismiss versus looking to settle is now. You've been served with a lawsuit. You are now in the game. And among the things that you're going to have to consider is not only the strength of your defenses and your resources and the other guy's resources, and maybe what the real truth is, maybe, but also another factor, which is, do you want this in your life? Do you want litigation in your life? That is a cost that's very hard to put a price on. And sometimes it's not a big deal. If you've got a big company, you've got people to take care of these kinds of things, and you're just going to keep doing what you do, and it's mostly going to be a matter of spending money. Then it's mostly a matter of spending money. But if you're a small or a medium-sized business owner, or you're an individual who has been sued, you're going to all of a sudden find that all kinds of confidences, all kinds of confidential information, all kinds of relationships, all kinds of data that you never wanted to share with anyone, you are going to have to share with others. Because if you didn't already know this, the American civil litigation system permits a tremendous amount of very, very invasive disclosure. And the process for the demand for disclosure is called discovery. In fact, it is pretty well known that there are some cases that people file merely to get discovery. Now, if you file a meritless case to get discovery, hopefully it will be dismissed as a meritless case before you are entitled to any discovery. There's one problem with that. Most courts these days, in most jurisdictions, are so backed up that they will let discovery proceed while considering the motion to dismiss. You might end up doing months or even years of discovery while your motion to dismiss is being considered. And in the meantime, if the judge decides your motion to dismiss is valid, the discovery will have been given. Oh, there are confidentiality orders, protective orders. There are all kinds of conditions, attorney's eyes only. We'll talk about that in more detail as we go on. But the pain will have been felt, and you will always wonder whether or not the stuff that you were assured would not be shared with anyone was. I'm not apologizing for that system, for the way it works. I think it's a problem, especially because most motions to dismiss really should not take that long. But there isn't anything really to force a judge to make a ruling in most courts. And in most courts, they will let discovery proceed. Therefore, that is a cost that you have to consider when you're filed with a complaint. How much of this do I want? Let's say I can afford it. Let's say I'm even right. Let's say I can even rebuild my brand or whatever the case may be. Do you want to be involved in litigation? You're going to have to make a lot of disclosures. You may put a strain on a lot of relationships, people that you would expect to help you by testifying or providing affidavits, uh, being available to you and not to the other side. It might surprise you. Your lawyer, hopefully, will talk about all these things when you sit down to talk about the lawsuit that you've been filed with. And of course, these are factors that we will discuss. I alluded to them as well, but when talking about the filing of the complaint, it's part of the pre-complaint investigation, because when you file a complaint and you serve it, you are bringing all these things down in your head as well. There could be counterclaims against you. There could be relationships that are strained. You may have to give discovery that you would otherwise not want to share with anyone. You might have shareholders that don't consider this to be a good use of company resources, all these factors. So before we talk in our next lesson about the particulars of responding to a complaint, it's of great importance to appreciate that this is put up or shut up moment. There will be others in the course of litigation. But if you settle in 6 months after you spent $1 or $2 or $300,000 on a motion to dismiss or on a responsive pleading that includes counterclaims plus discovery, whatever the case may be, if you end up settling the case that you could have settled, as soon as you got the complaint, you're going to be sore. What I often describe to clients is that the settlement question, and remember, the vast majority of claims do end up being settled. The settlement question is one that is a curve. At what point on that curve do you blink, and at what point on that curve does the other guy blink? Do you have the resources to continue litigating? Do you say uncle before the other side says uncle? You don't know what cards the other person is holding, and he doesn't necessarily know what cards you're holding either. You are guessing to a large extent where each side stands on that curve. And the kinds of things that can disturb that curve in terms of, for example, the funding of litigation include lawyers who will take a case that you wouldn't expect to be taken on a contingency, litigation funding, insurance coverage that covers litigation. That could be a good thing or a bad thing. When you find out that you have pleaded into coverage, sometimes you want to do that, sometimes you don't. If you do it, you have probably assured yourself a relatively long haul, because insurance companies, contrary to what most people believe, are not generally in the business of settling cases early. On the other hand, you probably have also pled into a pot of money that the insurance is obligated to make available to settle the case. These are complications that you have to consider the moment comes after you've been served with a complaint.